Welcome back to Sports and the Law, examining the legal evolution of America's three major leagues. We're updating now Chapter 3, the baseball trilogy, the MLB, CBA, and the baseball antitrust exemption. And Ellie has kindly agreed to help us put this script together, to help us walk through it, to help us understand how it plays back into everything that's in the book, and how these updates will guide us as we look at the next steps MLB and MLBPA may be taking as they head towards a really important negotiation, a renegotiation and renewal, we hope, of their CBA. So Ellie, thanks for putting this together. It's wonderful linkage of antitrust and perhaps taking away the exemption. And it all started, we've already talked about this under commissioner's authority, but now it becomes an antitrust issue, perhaps the exemption, which is a big part of Chapter 3. We won't burden the class with what that means quite yet, but take us through why this was a particular interest since we last got together as a class.
Absolutely right. So Major League Baseball's antitrust exemption has caught the attention of Congress after baseball moved the All-Star game out of Atlanta, Georgia, after the passage of the voting rights bill. Some members of Congress introduced legislation that effectively would abrogate the holding of the famous Federal Baseball Club case that's discussed on page 83 and 84, which established Major League Baseball's kind of enigmatic antitrust exemption. You had legislation that was introduced in the Senate, legislation was introduced in the House. Doesn't really look like the bill's going anywhere. So probably, not too much from a legal perspective that baseball has to worry about as of yet. But Michael McCann flagged what I thought was a very interesting kind of footnote to the discussion going on in Congress, is that baseball does have labor talks coming up. And the actual passage of legislation is not the only way that Congress can influence what goes on with private corporations, whether it's hearings or investigations and the like. And Michael McCann has suggested this could disrupt the upcoming labor talks, which I think are in a delicate and fragile place with the expiration of the CBA forthcoming on December 1st.
Yeah, really well done. And it is the baseball trilogy: federal baseball, Toulson, and Flood v. Kuhn, and then we get to the Curt Flood Act. But scope of the baseball's antitrust exemptions, page 89 and following, and we'll spend a lot of time on that. We can't quite pass over the antitrust exemption without referencing Alston for the regret about the holding. So we'll see. Follow that space. And thanks for footnoting back to those decisions, which draws the class back to those pages. Now, something I've been living through is the contraction of MLB. Again, the antitrust exemption was quite helpful here. It drastically reduced the number of minor league teams. Thank God our Lake County Captains were actually upgraded to high A. And the Staten Island Yankees, among others, forced to fold. Did not get their license renewed, filed a lawsuit. Has this got to be a contractual kind of case only, as you indicate here in your update, Ellie, because of the antitrust exemption? We can decide which minor league teams we have. Instructive here would be San Jose, perhaps a Miranda in the book, but take us through, and good find on your part. We've got all sorts of different claims here, but not an antitrust claim.
I think that's right, Professor. This is the classic case of the dog that did not bark. And so you have a contract dispute here, and the Staten Island Yankees are an example of one of them, where they hang their hat on a promise that was made that the team was going to continue perpetually to be affiliated with the Yankees. And so litigated as a standard breach of contract, breach of fiduciary duty. There's a tortious interference claim against Major League Baseball going on here, but not antitrust, right? And so we have, I think, what are becoming long-standing interpretations of the Flood Act and the antitrust standing that that act confers to Major League Baseball players, and conversely, the standing it doesn't confer. And the way that I think San Jose and Miranda and some of those other cases continue to operate now occurs perhaps on the front end when you're even planning out litigation and litigation strategy. What do you include in the complaint, and what do you decide this is not worth wasting, the court's time with, because we have, an understanding of where the antitrust laws extend to when it comes to baseball suits.
Really excellent summary. The Wade suit is another example. Senny has footnoted on page 95 under Miranda. That was the antitrust challenge by minor leaguers that fell under the weight of San Jose. But again, now this is really a labor law class action. It's a minimum wage class action that has been, again, opened, closed, and you've got the most recent update. And thank you for it, July of 2021. Again, not antitrust for the reasons we've explained, Ellie's explained. But where does this sit? And Save America's Pastime Act talks about go forward, but when on a retro basis, this could be expensive, very expensive for major league clubs.
I think that's exactly right. And Ryan gave an excellent summary of this in last year's Chapter 2020 update video. And the fact that we're still talking about this, just by the way, whether it's antitrust or whether it's labor, but a year later, is I think something that Major League Baseball and its lawyers would prefer that we won't.
Yep.
Right? This yes. Lawsuit has proceeded through a number of different hurdles when you're thinking about getting into court, certifying a class. And look, the latest order from July narrowed the class, and there was also an Article 3 decision when it came to standing for, to whom are the injuries fairly traceable, right? So now you can't go after the clubs, but you can go after MLB as the joint employer. Again, not an antitrust suit, right? Again, what are we talking about versus what we're not talking about? But at the same time, right, Major League Baseball does not like headlines about, latest development in lawsuit about the payment of starvation wages to minor league baseball players. So, baseball will continue to litigate this, but it looks like we've got a class action, and it looks like the suit is, at least for now, going forward.
Terrific. We'll talk more about it with our guests if they can, although it's in litigation, they may not be able to talk much about it. Again, now we come back to media rights, and this is where pardon the expression, the game really gets played in terms of, defined baseball revenue, the revenues that then the pie gets split in the negotiation. So there's going to be 48, 49, 50% of total gross revenues. And of course, broadcast revenues, these exclusive rights, implicates the Sports Broadcasting Act. Done a really good job of highlighting where we're going with this, Ellie, but these are really big numbers. And what does that mean to the next negotiation? Do they really want to kill the golden goose with all these media rights monies coming into the pot?
Well, I think when everybody's winning, everybody's happy, right? And so as the numbers keep going up, I think folks want to make sure that baseball continues to be on the field. There continues to be stuff for these networks to broadcast. And it establishes the broadcast networks themselves as major stakeholders with what's going on with MLB and the MLBPA and the like. I think it's important to recognize that, a lot of this course is structured around talking about antitrust law with relation to labor law and with relation to disputes between the leagues and the players. But there's an important, I think, side note when it comes to the governing antitrust legal structure. The Sports Broadcasting Act provides that immunity when you're talking about the league pooling its rights to negotiate certain broadcast deals. Now, the NFL and NBA, I think we're more familiar with that stuff, especially the NFL, because we'll see the nationally televised games on Fox, on CBS. You get Sunday Night Football, Thursday Night Football, Monday Night Football. The whole thing, if I want to watch on Monday night the Chiefs against the Broncos and I'm from New Jersey, I can do that. I just, I turn on ESPN. Major League Baseball for a long time has, been very reliant on the regional sports networks, which are discussed page 98 and 99 in the textbook. But I think baseball is also recognizing there is a national appetite for just watching the games. And so, partnering with various networks, including now Turner Sports, not just to have the games nationally televised, but also to utilize highlights. And it was, noted in the front office sports link that we provide. Major League Baseball is usually very stingy about the highlight rights, but they're allowing, Turner-owned platforms like Bleacher Report to utilize that. And I would think that, for the front office folks in Major League Baseball, they're hoping that this, continues to expand the game and make folks, I may be a Mets fan, for example, but I was really excited when Shohei Ohtani hit his 40th home run of the season. And I'd want to watch that. So that's the current state of play.
Amen. And just for clarity, thank you. Terrific update. SBA, back in 61, Congress enacted this as the bottom of 99. Exemption for league-wide contracts for over-the-air broadcast. Now, we're going to get into what that really means and how far the exemption should extend. And I think the other thing just to tease out is the territorial antitrust exemption that defines each, this is at page 98, as Ellie said, each territory belongs to each team. The bigger the territory, the greater the demographic, the better the regional sports network monies are for the Nessens and the Yeses, and not so much for the small to mid-market teams. They have less, not as much to spend because of the regional sports network media rights, and that creates an unlevel playing field going into the season, because the regional sports network monies and the territorial rights of the bigger markets give those teams arguably a pretty distinct advantage. It does not implicate, the CBA so much as it is allowable spending by each of the teams in each of its markets there. Okay, terrific. Thank you. These multimedia rights nationwide, they're split evenly among the teams though. Okay, here we go.
And I think that's it.
That's it. Well, this is terrific. We're going to have a lot more to delve into. I think the contraction in particular of the minor league, and we're going to have some links in our vault about how minor leaguers still are not treated very well by some of their parent clubs. And that goes back to in the game of baseball, do you build from the bottom up, or do you get the free agency guy as he comes into free agency, and how can you achieve free agency, which is really more getting into chapter 4. But this is a great summary of chapter 3, Ellie. And if Erin is still on, if you have anything to add, Erin, before we close.
I don't.
Perfect. All right. This will be uploaded. We'll have other links in what we call the vault attached to the syllabus. And please send in your updates each week and questions for our guests. And we'll look forward to getting through this chapter 3 with you as we progress through the course. So thanks for your continuing attention. And that's all for now.